Question: do Utah child custody laws and court rules ban minor children from testifying in child custody dispute cases? Answer: no, they don't. In fact, it's allowed, and provisions for child testimony can be found in the Utah Code at section 30-3-10 sub 1 sub e. A minor child cannot be forced to testify, but that doesn't mean children who are willing to testify can't do so. Sounds great, right? Well, hold on. Virtually all Utah courts hate children testifying. Some reasons seem valid, others more self-serving than legitimate. The reasons you'll hear most often for why a child who is willing and able to testify is nevertheless not permitted to testify are many. It is argued that testifying in any manner could traumatize a child. It is claimed that allowing children to testify drags them into the middle of the divorce, which in our opinion seems pretty weak, because unless the children are incredibly out of touch with reality, the kids have already been traumatized by and put in the middle of the divorce by the very fact of the divorce existing. And if after all that they are still willing to testify, we don't see the merit in the trauma or stuck in the middle excuses. Indeed, listening to the children's perspective and learning of their desires would help the children cope and help the court better understand and respond to their needs and desires. Listening to the children's input validates the feelings and experiences of the children, not the opposite. In fact, it seems to us that when a child is silenced and his or her observations and preferences aren't sought, that's what harms a child. Obviously, there are times when putting a child on the hot seat may do more harm than good, but courts use this possibility far too often as a blanket excuse for a policy of never questioning the kids under any circumstances. Oftentimes, a court will refuse to question or to hear from the children directly, claiming that although they are expressly authorized by the Utah Code to question children, they are nevertheless unqualified to do so. So then the court will instead appoint an attorney specifically for the child, known as a guardian ad litem, as if they are somehow magically better able to do the job than the judge. They aren't. You'll be told that guardians ad litem, or GALs as they are also called, are specially trained to question children. Nonsense. They get a few hours of training, much of it on YouTube videos like this one. GALs are hardly child questioning experts. No training available to a GAL is denied a judge anyway. They can and should get the same training. Worse, though, is that while having the judge question the children is first-hand and free of charge, when a GAL is appointed, the court orders one or both of the parties to pay that lawyer. Worser, for lack of a better word, the questioning of the children by a GAL is not required to be on the record. You heard right. The GAL questions the children and then gives a second-hand account or summary to the court as to what the children were allegedly asked and what they allegedly said in response. And then the GAL makes recommendations to the court regarding the child custody award based upon testimony that was never recorded for the record for review. So if the GAL is biased, asks leading questions, forgets to ask certain questions, misstates what the children said in response, or makes a recommendation diametrically opposed to the children's best interest, nobody will ever know. That's the law in the state of Utah. You are not obligated to listen to what the children have to say in a child custody dispute, but they can do it, and frankly, they should. But most judges almost never do. Does that mean you shouldn't try to have the children's testimony a part of the record in your case? We don't think so. Nothing ventured, nothing gained. Thanks for coming to Client School.